Can an accused claim bail as a matter of right? The term bail is not defined in the Code of Criminal Procedure, although the term bailable offence and non-bailable offence are defined under Section 2, Clause A of the Code of Criminal Procedure. According to this, bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable offence means any other offence. The first schedule, as contained in the Code of Criminal Procedure, for classification of the offences where bailable and non-bailable, cognizable and non-cognizable offence are mentioned. The provisions relating to bail and bonds are mentioned in Chapter 33 of the Code of Criminal Procedure from Section 436 to Section 450. Bail is rule, jail is an exception. This is a judicial principle that was laid down by the Honorable Supreme Court in a landmark judgment of the case State of Rajasthan versus Walchand alias Balia in 1977. In this case, the Honorable Supreme Court ruled that the basic rule is bail, not jail. Except where there is a risk the accused may flee from justice or interfere with the course of justice or repeat offences and intimidate witnesses. The legal doctrine in this case was laid down by Honorable Justice B. Krishna Iyer, who based it on fundamental rights granted by the Constitution of India. For the purpose of the bail, the offences are classified into bailable offence and non-bailable offence. An accused can claim bail as a matter of right if he is accused of committing a bailable offence. What a person accused of a non-bailable offence cannot claim bail as a right. In bailable offence, the police or any other authority has no right to reject the bail if the accused is ready to furnish the bail under Section 436 of the Code of Criminal Procedure. Section 436 of the Code of Criminal Procedure says that in what case bail to be taken. According to this, when a person other than the person accused of a non-bailable offence is arrested or detained without warrant by an officer in charge of a police station, appears or brought before the court, and is prepared at any time when in the custody of such officer or at any stage of the proceedings before such court to give bail, such person shall be released on bail, provided that if such officer or court, if he or it thinks fit, may and shall, if such person is indigent and unable to furnish surety, instead of taking bail from such person, discharge him on executing a bond without sureties for his appearance. Explanation: when a person is unable to give bail within a week from the date of his arrest, it shall be the sufficient ground for the officer or the court to presume that he is an indigent person for the purpose of this proviso. Non-bailable offence. Non-bailable offence means an offence which is not a bailable offence. In case of the non-bailable offence, the accused cannot claim bail as a right. Section 437 of the Code of Criminal Procedure says that when bail may be taken in case of the non-bailable offence. According to subsection 1 of Section 437 of the Code of Criminal Procedure, when any person accused of or suspected of the commission of a non-bailable offence, arrested or detained without warrant by an officer in charge of a police station, or appears or brought before a court other than the High Court or Court of Session, he may be released on bail. What subject to? Such person shall not be released on bail if there appears reasonable ground for believing that he is guilty of an offence punishable with death or imprisonment for life. Such person shall not be so released if such offence is a cognizable offence and he had previously convicted of an offence punishable with death, imprisonment for life, or imprisonment for 7 years or more than 7 years. Or he had previously convicted on 2 or more occasions of a cognizable offence punishable with imprisonment for 3 years or more than 3 years, but not less than 7 years. Provided that the court may direct that a person be released on bail if such person is under the age of 16 years or a woman or a sick or infirm. Special powers of the Honorable High Court and Court of Session regarding bail are mentioned under section 439 of the Code of Criminal Procedure, and we may apply regarding bail to the Honorable High Court or the Court of Session under section 439 of the Code of Criminal Procedure.